Welcome all of you. A very good afternoon, and we welcome you back to the series, to Founders 101 series. As a quick recap on the sessions that we've already taken in these series for the for our startup and founder audience, we took the first session was centered around impact of COVID-19 on startups, and when can you invoke force majeure clauses in your contracts. The second on startup policy, where we discussed exemptions and tax exemptions and other benefits that are granted under the policy. The third was on employee stock options, about drafting a plan and the key considerations. And the fourth around how to choose your investor and the key clauses in a term sheet. And basis the feedback that we've received, we are, we curated this session again on externalizations or flips, on how to structure or how to, when to take your startup abroad or to other jurisdictions. Let's, to begin with, let's understand the three concepts around flip. One is what is involved in a flipping. Second, when should you flip? And third, why should you flip? Before we start off the session, quickly to answer these three questions to set the tone for today. So generally speaking, you should try and avoid the need to flip by simply incorporating your holding company from the outset in the most investment or the business friendly place, if you could choose. But since that's not always possible, example, for instance, where you've received seed money to finance your early stages of the startup or the business, you can decide to flip it later. In case you decide to flip your company later, then the earlier earlier you act, the better it is, for all the reasons that we will lay down here. Otherwise, the potential restructuring can just become harder with every, with the passing of the time. Example, intellectual property and the key commercial and employment agreements may need to be assigned to the overseas incorporated company. It also may become difficult, in terms of your replicating the shareholding pattern in the new holdco. Now, what is essentially involved in flipping? Flipping essentially involves registering a holding company in another host country, for example, US or Singapore, where the main jurisdictions that we will be focusing our session on today, or any other jurisdiction which works better for you in terms of business interests and tax considerations. What essentially happens is that the shareholders of your existing company will swap their shares for an equivalent number of shares in the new holdco. And the end result is that the existing company becomes the wholly owned, subsidiary of the overseas entity which you have incorporated. Of course, there are different structures in which flips can be achieved, and we will be discussing them in the course of this session. While most of them depend on how on a case-to-case basis and at which stage you are approaching the flip, but we'll try and cover some of the possible scenarios in this session today. Often startups feel pressured to flip at the time, of a proposed capital raise, sometimes also at the request of the investors. Just a word of caution here, that term sheets which are signed up by the investors where they are promising investment based on the company flipping, you just remember that they are non-binding, and such promises where the investment is based on the company flipping may not materialize into an actual investment. So let's get into why should you really flip your company to another jurisdiction. The most important consideration that you should keep in mind and you should think about before you decide to flip to a jurisdiction is the business consideration. You need to have a real strong business case before you decide to flip. When you say a business case, the first thing that should come to your mind or occur to you should be, is your real customer base lying in the jurisdiction you're deciding to flip? Would you be able to acquire more customers and they will be value, in terms of your business that you will see in those places? Your location of IP becomes second important factor that you should consider. Besides the legal and the tax consideration, which are also associated with every jurisdiction, we will specifically analyze US and Singapore in our session today. And, from here on, I would take it to Parul and direct my first question to Parul. Parul, is tax or should tax really be the only determining factor for you to, consider a flip?
Thanks, Harshita. I think till a few years back, companies were actively looking at flipping in other jurisdictions, primarily for tax reasons. But now, if you look at the reasons why startups are really looking at flipping in other countries, is not really tax. Tax may be a part of it, but also more so the flipping involves, sure that there are no adverse tax consequences. Many times we have seen, and this is for more so for US companies or US companies that are acquiring Indian companies. There are a lot of accelerator programs that are set up in the US, and it may be a dream of any entrepreneur in India to be part of such an accelerator program and to to get the mentorship and the seed capital from the accelerator program. These accelerator programs, and they're run by by institutions like Y Combinator and the like. 500 startups. They also have a accelerator program. They only accept US companies into the accelerator program. And this is a requirement that the entity needs to be incorporated in the US in order for them to be accepted into the accelerator program. So more so, you will see that the Indian companies then set up a holding company abroad in the US and make that as part of the accelerator program, and then make the Indian company through an appropriate structuring method, make the Indian company as a subsidiary of the overseas entity. I think that's one reason. The other reason why one may be looking at flipping is ease of capital. Even now, investors feel much more comfortable investing into an overseas jurisdiction as compared to India, where the terms of their investment can be governed by non-Indian laws. And they just feel very comfortable in signing certain standard form documents which are more prevalent overseas, as compared to signing a document which is heavily regulated as per Indian laws. Although this may not, I don't think this should be really a deal breaker in that sense. We see a lot of transactions happening directly into India, and more so of those happen directly into India. But for some startups and some particular investors, they always prefer investing into an overseas entity, which would then invest in India. They may also prefer to invest in an overseas entity because probably it may also give them some flexibility to put in some debt. And debt can be invested in India only after following certain restrictions and only after following certain norms. So ease of capital raising is another criteria. The third criteria would be the operations, the expansion plans of the startup. Many times startup would they would have a global dream of expanding their venture into global companies, and more so then the question comes, which should be the right holding company for which would be appropriate for their expansion plans, for the future expansion plans. It is quite difficult to restructure at a later stage, and even when new investors are coming in and they look at the plans of the startup for the years to come, they usually recommend that some foreign companies, some foreign holding companies should be set up, which could hold India as well as companies in the future. It would also have there would also be an ease of hiring the right people in the right jurisdictions. Of course, there would be ease of taxation. Having a holding company would avoid paying certain high taxes in high jurisdictions, but accumulating value at a certain level as well. And I think that's also really important, because when you set up a holding company, you end up accumulating value at one level as compared to India, and then there could be there could be an exit at the holding company level, which could result in either a strategic sale at the holding company level. It could also result in a listing of the overseas company. Now, when you're starting out with a new venture, one of the thoughts that comes to one's mind is what really should be the exit plan of this venture. Of course, when you're just starting out, probably looking at exit is not really the first thing on one's mind, but is building a profitable and a valuable business is something that's on one's mind. But exit usually follows, and we have seen a lot of companies that have flipped abroad, and then subsequently they have listed on foreign exchanges. Today, our Indian law does not really allow an Indian company to list directly abroad. And while there are some relaxations which are expected down the line, but till the time those don't come in, it's much easier to set up a holding company abroad and then list the company abroad. So number of factors why one would really look at flipping abroad, or why companies may look at flipping abroad, but that's all very commercial. I wouldn't really say that tax should be one of the main reasons why one should consider a flip. Of course, in order to satisfy the business parameters, it's possible that one may structure the entire flip to ensure that operationally, taxes don't get stuck, or you don't end up paying taxes in more than one country without having appropriate credits. But probably, just even after thinking through the business considerations, I don't really think that one can just decide to flip like that. There are a lot of structural issues that come in. India is not fully convertible on the capital account, and hence, swapping of the shares of an Indian company with a foreign company where Indian promoters are concerned could be an issue. There could be issue for Indian funds, which may need a SEBI approval in order to invest in an overseas entity. And we'll talk about, how SEBI also looks at some of these flips. And, there could be other exchange control considerations that may need to be borne in mind. But Harshita, I think over to you, since we started talking about exchange control and regulatory considerations. Why don't you give an overview of what a startup may need to look at, and specifically which has a mix of Indian promoters as well as looking to get overseas capital? Does it always work from an exchange control perspective?
Sure. Thank you, Parul, for directing that question. So, the moment we think of flips and we look at the exchange control regulations, one of the terms that all of us have come across and we keep hearing is round tripping. So, does it essentially mean that the Indian parties, what does the term round tripping mean in common parlance? So the practice of investing back into India through a foreign holding company is what is called round tripping. There is, unfortunately, while the concept of round tripping, is envisaged in the laws and that we have, and I will just touch upon those laws right now. There is no clear definition of round tripping or the term used as such in any of the Indian regulations. Historically, Indian parties have been taking advantage of friendly tax treaties with the countries where such holding companies are set up to invest monies back into India. However, the Reserve Bank of India has traditionally frowned upon, round tripping practices because one, not only does it, encourage tax avoidance, if I may say that, but also it is also used as a route to launder black money into India. In May 2019, the Reserve Bank of India updated its FAQs on the ODI regulations, which is overseas direct investments, which further got updated in September last year, where it is expressly clarified that Indian parties are not permitted to set up an Indian subsidiary through its foreign entity or a joint venture entity. And nor do the provisions permit an Indian party to acquire a wholly owned subsidiary or invest in a JV that has a direct or an indirect investment into India under the automatic route. Now, there has been an exception which is granted by the RBI to the extent that if you need to do that, you can approach the Reserve Bank of India for a prior approval through your AD bank. And the Reserve Bank of India will consider it on a case-to-case basis whether to allow you to indulge in such investment or not. Now, therefore, to monitor, if you see, to monitor or to counter the round tripping practices by Indian parties, the FAQ contemplates a twofold ban on Indian party. Indian parties seeking to use the automatic route for such investments. Now, one is by way of setting up an Indian subsidiary through your foreign entity, and second is by way, when you already have a foreign entity and you want to acquire another Indian entity through that foreign holdco. Now, although the RBI implies that a restriction around round tripping practice has always been inherent under the ODI regulations, it should be noted that there is no express language, which prohibits such a practice. So it's more in terms of how the RBI has been reacting to cases and how we have seen our clients approaching us when it comes to, them receiving, notices, etc. for investments being made like these. The second important part in foreign exchange, which we need to be careful about, is that how do promoters or Indian parties really remit the money outside India to to acquire the shares or to set up the foreign entity. So under the liberalized remittance scheme, resident individuals, including the minors, are allowed to freely remit an amount up to USD $250,000, per financial year, for any permissible current or capital account transactions or a combination of both. So you can use that limit to go ahead and acquire securities of a foreign holdco, and thereby I'll get it back to from here on I'll get it back to to Ashish in terms of what are the tax considerations besides these, which you should bear in mind when you're deciding to set up a structure, or flip your structure.
Sure. Thanks, Harshita. So I think Parul touched upon maybe some of the ways in which we can do a flip. Now, a flip could be done in multiple ways. Some popular ones is what maybe I can quickly discuss and possibly provide you with some uh, broad tax implications when you are planning to do so. Now, in a flip, what we need to understand is that generally the investor in the Indian company and the promoter would want the same shareholding to take place even at the foreign holdco level where you'd like to set up your holdco entity. Now, under this, what really happens is it becomes important to provide them with that exact percentage. At least the investor at the Indian level would want the same percentage at the holdco level also. Now, apart from the tax jurisdiction which we are going to be discussing, or the jurisdiction where you want to set up your entity, which we're going to be discussing in a slightly in a couple of minutes. The couple of ways in which popular ways in which we can consider a flip is when the foreign holdco buys the shares of the Indian entity directly from the promoters and the share and the investors of the Indian company. Here, a couple of things to be borne in mind. Of course, firstly, we have to consider round tripping and LRS and all of those factors that Harshita pointed out. But from a tax perspective, what needs to be understood is that the shares of the Indian company, when sold by the resident, will have to be at the fair market value of the Indian company. If they are less than the fair market value, then there is a risk of taxation on both the seller and the buyer, which should be kept in mind. The same thing goes for the non-resident also. Now, in a situation like this, what effectively needs to be understood is that when the foreign holdco is set up, the foreign holdco will have to be capitalized to the extent of the value of the Indian company. So if you have a foreign investor who is coming in, he'll have to first put in money into the foreign holdco, which will then be able to acquire the shares of the Indian company, pursuant to which the foreign holdco will become the parent of the Indian company. Separately, we'll also need to consider how the Indian promoter or the Indian shareholders will become shareholders of the foreign company, considering various round tripping ODI regulations. Another way of doing this would be where you do not want to enter into a share sale arrangement, but you would like to consider something like a business undertaking, transfer of business undertaking, where the foreign company sets up an Indian company, and the Indian company then buys the business of the current Indian company in which the business of startup or is ongoing. Now, in a slum sale, what is essential is that the transfer of business has to take place on a going concern, and any gains that the Indian company selling the business makes is subject to capital gains tax in the hands of the Indian company. So what effectively happens again in this situation also is that the foreign holdco will have to be capitalized by the investor, which will then give money into the new Indian company, which will be set up in India. That Indian company will then be able to transfer buy the business of the current Indian entity. Once the current Indian entity receives the money, naturally the promoters and the investors in the Indian company would want to get that money back. Now, this again would result in multiple tax consequences because depending upon the method we choose to release these funds to the investors and the promoters. So all of this will need to be considered and thought through before we can, consider a flip in situations like this. A third option, which is perhaps a more newer option, considering corporate laws and regulatory issues is that of an outbound merger, where the Indian company a foreign company is set up, and then the Indian company then merges with the offshore company. Now, this again has just been permitted, and while it is allowed from a corporate perspective and a regulatory perspective, multiple approvals are required by the RBI and also by the NCLT. Apart from that, from a tax perspective, unlike in the case of other amalgamations and demergers, where benefits have been given, there is no benefit currently for an outbound merger, which means that on the outbound merger, there is going to be tax on the investors as well as on the promoters of the Indian company. Well, this was basically with respect to how you would want to perhaps do your flip, externalize your business. But then after the externalization, the important question comes in is how would you, what are the challenges of running these businesses when they are outside, right? I think one of the major challenges that we look at today is that of place of effective management, as we call it as POEM. Now, POEM is essentially very, very important to be considered when you are considering a flip, because in all possibility, the Indian promoter is going to remain an Indian resident. And when you are actually setting up a foreign holdco, which is going to effectively run the business, but you are sitting in India and taking decisions as a director of the foreign holdco, then there is a risk that the foreign holdco could be considered to be the foreign holdco could be considered to have its place of effective management in India. Place of effective management is a really broad concept and really subjective, and needs to be looked at on a case-to-case basis. There is no objective criteria to the place of effective management. You can take in more details about the place of effective management with the cCep that was done a couple of weeks earlier, where we got into details about what the POEM is, what the threshold is, what the criteria is, and how we can look at whether POEM of a foreign company is situated in India. One thing that we must consider in the case of there being POEM in India is that the foreign company will be subject to tax 40%. Now, that is a very, very huge amount of tax that you will end up paying, and which will perhaps be a disadvantage to your flip in case something like this happens. But yes, that is something really, really important and should be considered before considering a flip. So I think, Parul, I think there's another important consideration which I think you touched upon when you were speaking about externalization, which was respect to anti-avoidance. You want to take that up?
Yeah, sure, Ashish. Thanks. And I think before just anti-avoidance, Ashish talked about how you should run your business after the flip and all the POEM concerns. I think one more issue which we've seen quite often, which is not realized by a lot of promoters, is that if your team is actually based in India, your IP is in India, and your all the work is actually happening in India, the foreign entity may be doing just it may just be holding the Indian entity, or at best it could possibly be doing some marketing functions. And what will happen in that case is that due to a transfer pricing study that may need to be done for the relationship between the foreign entity and the Indian entity, it may be possible that while you may be booking revenue at the offshore level, a lot of that revenue may still need to come to India under an appropriate transfer pricing study. And if that happens, then in any case, you would end up paying all the tax in India. Of course, this depends a lot on what are the functions which are being carried out at an offshore entity, who are the people who are involved there. It also ties in with the POEM risk, which Ashish is talking about. But basically what we're trying to say is that, structuring for a flip does not merely mean a structuring for ensuring that the Indian company is a subsidiary of a foreign company, but it goes way beyond that. And it also covers the operational aspects from a POEM perspective, as well as from business operations perspective with respect to the functional analysis that may need to be done for the foreign company as well as the Indian company. And that's where even anti-avoidance comes into play. Now, when we talk about a flip structure, anti-avoidance actually comes in play at different levels. But before we get into that, let's talk about what really is anti-avoidance. And since this is a session which is for startups and for promoters, it's good for promoters to know what tax avoidance really means and how tax authorities are really dealing with that. The Indian tax law came out with a rule in 2017 stating that if any transaction is being done and the main purpose of the transaction is really to avoid tax, then they can do a number of things, including just ignoring the transaction or taxing the transaction or applying different taxes in the hands of different people. So it's really important that when the structuring takes place, in the context of keeping the context of the anti-avoidance rule in mind. This can apply in 2 or 3 ways. One is when the promoter is holding shares in the foreign entity, and either there is a new entity which is set up in India, or the Indian entity's shareholding of the promoter, it dilutes to a very insignificant level. Tax authorities could actually view that as a swap of shares, and specifically if the the amount which is being sent by the promoter to acquire the shares of the foreign entity is very little. And generally what would happen is that when a holding company is set up abroad, the holding company would have nominal share capital, and if that happens, then the investment that goes from India may also be nominal. Whereas ultimately, when the foreign entity ends up holding shares of the Indian company, the value may be much higher. So tax authorities could argue that there is a kind of a swap of shares that's happening, and under Indian law, swap of shares is taxable. So that's something which the promoter needs to watch out for, and ensure that there are appropriate commercial arguments and justifications. Tax authorities are very averse to any sort of a structure which involves giving up anything in India and getting something overseas in return. And I think Harshita also alluded to that. While that's more of a round tripping from an RTA perspective, but even tax authorities do view some sort of a round tripping as being done in the context of avoiding any tax. Whereas actually, if you look at it, if a promoter is holding shares in an Indian company and the exit happens at an Indian level, the promoter would pay tax on sale of shares of the Indian company. But if the exit were to happen at the Singapore level, then also the promoter would pay tax in India. So it's not that, there is some sort of a tax leakage that's happening. In fact, if the Singapore or the US company were to sell shares of an Indian company in any sort of a structuring, it would pay tax in India, and subsequently any repatriation to India would mean another tax in India. So these type of tax aspects need to be kept in mind. The other issue where anti-avoidance could come in would be, again on the structure side. So, for example, if at the India level, the structuring is taking place in the form of a slum sale of the business of the Indian company, the existing Indian company, to a new subsidiary of the foreign entity. In that case, also, tax authorities could argue, depending on how the slum sale is being structured, that it is it's a sale of assets, and there should be an arm's length compensation that needs to be paid to the Indian company for exiting its business, and that's where another anti-avoidance question could come in mind. And the third area where anti-avoidance could come in is on the operational part, where if the revenues are being booked at an offshore level, whereas most of the work is being performed at the India level. Of course, we talked about how transfer pricing will also need to justify that. But that's also another area where tax authorities could argue that, the entire holding structure has been set up in order to offshore India revenues. And in reality, those revenues, if they would have been booked in India, then there would have been a tax in India. There could also be a question with respect to transfer of IP. And IP is the most, it's the most valuable thing which startups have. Startups are set, they formed a new product, and IP is the most valuable thing to them. Unfortunately, it's not something which can be, valued very appropriately. Valuation of an IP is very subjective. It could have a certain value in the minds of the investors, it could have a certain value in the minds of the promoters, and it could have a certain value in the minds of the tax authorities. Transfer of an IP to a foreign entity could again entail tax consequences, and tax authorities, while challenging the transfer of the IP, could also deal with tax avoidance in that context, and argue that the IP was transferred at the time when the value was assumed to be low, just so that the revenue on account of usage of the IP could be captured outside India. And of course, doesn't mean that tax authorities could question each and every step of the flip or the operational part, but probably the way that the structuring is done is going to be key to ensuring that we have answers to all of these questions. For example, in the case of an IP transfer, if IP is getting transferred, then in that case, and if the Indian entity is going to be using the IP, then there will need to be an agreement between the Indian entity and the foreign entity for usage of the IP. And all of these aspects need to be looked at on a wholesome basis, before deciding on whether the flip is going to meet the rules under India's anti-avoidance law. I think, Harshita, over to you. This is what I had to say on the anti-avoidance issue.
Sure. I think, and Parul, just while you're here, to take up a question which has come from an attendee, and I think you already touched upon that earlier in the session in terms of when you were emphasizing on what are the benefits of flipping it to a different jurisdiction, and when it comes to listing, you consolidate the value in an offshore, listing in an offshore jurisdiction. So a question that comes to the mind of a lot of these founders, and it has already also come from an attendee here, is there a way we can reverse the flip, which is make the parent into a subsidiary and subsidiary becomes the parent? So, can we just explain that quickly in a line, though we've already touched upon this while explaining the advantages?
Right. So I think we're talking about the reverse flip then. We want the Indian parent to be the Indian parent. And I think Ashish spoke about an outbound merger. But if we want to reverse the flip, one way to do it is to do an inbound merger. And when you do the inbound merger, then, that's of course, it could take a bit of time to get appropriate approvals, but that would be tax efficient. There would also be a commercial rationale why we want to, merge the entity into India. And when you merge the foreign entity into an Indian entity, then the shareholders of the foreign entity would become shareholders of the Indian entity. And there's also tax exemption for this type of inbound merger. There could be other ways as well, similar to the way that you do a flip. You could reverse the flip as well, but of course, very fact specific, and also depending on the stage at which the company is.
That's helpful, Parul. I think the other question I'll quickly.
I think just one point, Harshita. Sorry to cut you. I think Nishith Bhai also had a comment here. Nishith Bhai, do you want to talk about the inversion rules in the US? And do you have a comment there?
Yeah, I think when you do reverse flip, that means you have a US parent, and that becomes a subsidiary of an Indian company. And now the typical rule in the US is that the US taxes the companies on a worldwide income if they are incorporated in India. They incorporated in the US, I'm sorry. Now, in the US, there are no rules of control, management, and stuff like that. Only incorporation is the criteria. When you reverse flip, what happens is the inversion rules will make the US investors taxable on the transaction immediately, and there could be significant tax at that point of time. And also, after the flip is done, in some circumstances, they may still consider a foreign company after the flip, which becomes a parent company, to be like a US resident company. So there are some complex, and it's one of the most complex structuring that one has to go into. At one point of time, I remember that, there was a US parent company. It had about 300 employees, and the inversion was to be done. Now, what happens is that the employees who are having stock options have to be given shares of Indian company, and when they are to be offered those shares, now it becomes more like a public, offering. So they have to go through whole process. So what was thought to be a very simple transaction of flipping from the US into India inversion, it turned out to be like an IPO. And what would have cost $100,000 became close to $1 million, because there's so many complications, because there are options, and in the US, the US shareholders, if they are offered shares of Indian company, when they sell the Indian company shares, the tax credit issues in the US, and so on and so forth. I won't go into the details, but the flips could be very expensive if you have to reverse from the US in particular to India. But if it is in other jurisdiction, the things are slightly easier. So one has to bear in mind those. So all that I wanted to draw attention was that once you flip, and then to reverse flip could be a significant tax. It could incur significant tax cost, and we can deal with that in a separate session sometime on the inversion itself. But coming back to your answer, this is what something you must bear in mind. So, uh, just take care of this.
Thank you. I think thank you all of you in terms of answering this question, and I'll quickly pick up on one or two other questions by the attendees before I move on to Ashish for for the question around US and Singapore. A lot of participants have the question that is there a way we can counter round tripping, or is there a way we can counter poem, or whether loss making entity is the only criteria which can determine poem. So just to answer it quickly in one line, the way to counter round tripping, so there are structures which we broadly discussed, where we have to carefully examine the case and the facts and circumstances of each entity with respect to their shareholding pattern. What stage are you deciding to do that? Which jurisdiction are you deciding to do that? Before we can answer the question. There is no straight answer to how you can avoid the round tripping, and which is why structures and a careful analysis of all the laws, exchange control and tax, come into play when we are devising structures around externalization. So there is no one clear answer on how do you avoid that. On your question around the Indian entity being a loss-making entity, and would poem really pose a risk there? So poem is a broader concept when it comes to tax, for the purposes of determining the tax residency of the offshore entity. So it is not merely whether the loss making, and whether the entity has been making a loss is not the only criteria on the basis of which it can be determined. There's several other things that come into play when we determine whether the structure poses a poem risk or not. So now, from here on, moving on to Ashish. Ashish, another important consideration besides the legal, tax, and commercial, considerations that we just discussed is the choice of jurisdiction, essentially. So, can you just throw some light on what are these considerations in case, we decide to go to Singapore or US? And obviously this is, basis the fact that a lot of these startups are now, wanting to move their base to Singapore and US. Not only because of tax reasons, but also because of the ease of doing business in jurisdictions like Singapore. So if you could just throw some light on the benefits of these places.
Sure. Thanks, Harshita. So I think Parul, has spoken about how it is very important that your business considerations need to be put in place. And Harshita, you also spoke about how business considerations are the most important today when we are deciding to do a flip. It's no more that tax is going to be the only reason why you should consider a flip. Business reasons and other marketing, etc. reasons should be considered when you do a flip. Now, when it comes to choosing a jurisdiction, I think in terms of the choice of jurisdiction, some of the most important considerations that should be borne in mind before we consider tax today as the key reason why you want to move to a jurisdiction should be, what is the strategic advantage for the business in terms of branding, accessing markets in that jurisdictions? What about the safety of the investment? Is there a bilateral investment protection agreement with that country? What are the type of legal system? Is there a civil law, common law? What types of entities can be incorporated in these jurisdictions? What are the types of instruments that are allowed? Are there any exchange control and regulatory compliances that need to be adhered to? What is the quality of administrative support services that we are going to get? The banking network in that country. I think the protection of intellectual property in case of IP-driven business. All of these reasons are very important to consider before we go into what the tax costs and relief under tax treaties available in these jurisdictions are. It is basis these reasons that we will be able to justify, how we wanted to go to a jurisdiction which provided us with all of these benefits, and then came tax, and therefore, even from an anti-avoidance perspective, it becomes quite significant to understand. Now coming to Singapore and US. Well, Singapore today is a very stable economy, has excellent infrastructure, business friendly environment. The government provides a lot of support to investors doing business in Singapore. In terms of ease of doing business, I was just checking the ease of doing business ranking by the World Bank, which provides that Singapore currently ranks number 2 in that. But in terms of efficiency of dispute resolution, global competitive index, it still ranks number 1, and that is something significant that should be borne in mind when you are deciding to choose Singapore. And in terms of accessing markets, also Singapore from a Southeast perspective can be a great jurisdiction to think about. Apart from that, from a tax perspective, it has a low corporate tax rate of only 17%. There is no capital gains tax. There is exemption for inbound dividends in certain circumstances. There is no withholding tax on outbound dividends. There is 15% tax on interest and 10% tax on royalties. It has about tax treaties with about 60 countries. There are special incentives given to IP and R&D activities. No thin capitalization or CFC rules, that's controlled foreign corporation rules in Singapore, which makes this jurisdiction a great jurisdiction from a business perspective, let alone what the tax benefits are. You would want to choose a jurisdiction basis your market. This is where your business is. But if you are looking at a South Asian market where you think your customers are going to be, then Singapore can definitely be one of the jurisdictions we could think of. The other jurisdiction I think that we are focusing on today is USA. Now, USA, as Nishith Bhai said, USA can be quite complex when it comes to taxes. But from the perspective of the markets of the business there, well, you could set up your business in any of the states that in USA, depending on where you would like to build your business. There is Delaware, there could be California, there could be New York, in any state that you want. Of course, the tax rate differs from state to state. So the US follows a 3-tier tax rate, where there is a federal, then there is a state, and then there is a city level tax. Currently, the federal tax rate has been reduced to 21% from 35% by the Trump administration. And the level tax that also becomes payable. However, even adding that up, an average goes up to about 25% tax in the US, which is also a great advantage. And considering that we are moving to the jurisdictions where we would like to build our business, I think US is one market that we have seen growing in terms of IT companies going and doing business and looking at their customers in the US. And therefore, from that perspective, US definitely works if your market base is the US. Other tax perspective, I think US has a number of treaties with a number of countries, but then again, US provides for a more complex tax rules than other countries, which should be borne in mind at the time of choosing US as a jurisdiction for your holding company. I think that's it. That's all from my end, Harshita.
Thank you. Ashish, do you want to pick up a few questions which have come on US and Singapore, meanwhile, and I will, just touch upon, in the meanwhile on how important is the documentation of this entire structure, when it comes to, flipping your entities. So it's not just merely about incorporating a company or taking the help of of a local administrator or a local service provider in those jurisdiction and setting up your entity. It is very important to document every step of your, in terms of your flip, whether it's transfer of IP by way of a license or an assignment agreement, whether it is employees, whether it is service contracts whereby your Indian subsidiary is servicing contracts on behalf of the US entities, or it be the entire, the shareholders agreement between the tying up the two entities, which is between your holdco and your subsidiary. So remember to document every part of the transaction so that you're creating substance, while you are doing so. And tomorrow, if a regulator picks up, you can produce those documents and show that there was, the validity and the reasons behind the structure. I think the other, I would like to conclude before I hand it over to Ashish and Parul for some of the Q&As. The other important consideration besides the one that we discussed is the cost of setting up the structure in that jurisdiction and the cost of maintaining that structure. So while you may have business considerations to move outside India, and you may have the law by your side when you're deciding to do that, please understand the nuances around setting up. The cost of setting up a structure, as we've been doing it, for a lot of them recently, is, specifically in the US, is ranges about USD 10,000 to 15,000 in terms of setting the structure up, and when it comes to running the structure, probably for a year, the local administrators charge you about USD 7,000 to anywhere around USD 10,000. So and about on the similar lines for Singapore. So please ensure that you have that cash appetite to spend on the structure, because it's just not about setting it up, but it'll be also about maintaining the structure as per the local local laws. From here over on to Ashish, and Parul, to answer some of the questions, considering we have about only 10 minutes left with us. So, we will try to answer as many questions as we can in the span of this session. Whatever we cannot, we will, get back to you guys separately. Ashish?
Sure. I'm just going through the questions and.
Sure. Meanwhile, Parul, in case you want to pick up any question, from the list.
Yeah, sure. I think I'll take up a couple of questions on, gift and round tripping. I'm just going through the list, and, I'll just pick up the questions as they come by. There's a question with respect to whether a gift of shares can be made by, by a non-resident to an Indian resident, and whether the gift requires prior approval. And there's a related question by someone else, which is asking whether such a gift would result in round tripping, because there would not be any fund movement. So now there are two aspects here. One is, the gift of a foreign company shares by a non-resident to an Indian resident. Technically, that is permitted under the provisions of foreign exchange rules and regulations. However, we have seen RBI get a bit concerned with respect to such gifting structures, and especially since there is no relationship between the non-resident and the Indian resident. Generally, a gift under the Indian common law requires a natural love and affection, and something which is being done for business purposes may not really then qualify as a gift. I mean, you can enter into a gift deed and call it a gift, but is that really a gift? And especially if it is being done in order to avoid, the rules and regulations under FEMA. So we would be quite, averse to just, going ahead with a gift structure. And where round tripping is concerned, I think the view that is being taken by RBI, and also given, I think Harshita talked about, an FAQ and ODI which had come out some time back. The round tripping issue is just not with respect to holding shares in a foreign company where money is being sent from India, but whether value is being, derived indirectly from an Indian entity by an Indian resident back into India. That's really how round tripping is being viewed at now, and not just merely, funds going and coming back into India. Ashish, do you want to jump in with one or two other questions while I'm looking at the list?
Sure. So I think there has been a couple of questions on valuation also flips. So on valuations, what we need to understand is that under the Income Tax Act, there are valuation methodologies which have been prescribed. What we need to be sure of is that if your share sale takes place, whether at the time of doing the flip or whether at the time of exit, if the share sale takes place at values which are less than the fair market value, and the fair market value is actually the determination of the fair market value is actually provided under rules under the Income Tax Act, then there is a risk of tax on both entities, the seller as well as the buyer, which needs to be understood very carefully when you are deciding to a flip. And I understand, as many of the questions also are here, that what happens in case of a loss-making company. Well, if the Indian entity is a loss-making company, then we'll need to relook at the valuation to understand if the valuation is at a at a lower threshold, then it may just work for you when you want to decide to actually flip because of the low valuation, which becomes important a consideration considering the taxes you may end up paying if the valuation is very high. I think that was a set of valuation and capital gains, which are some questions. I think there are some questions on demerger, merger, amalgamation. So I think generally putting it out there that there are various benefits, various exemptions available under the Income Tax Act when you are deciding to demerge or do a merger or amalgamation or a scheme of amalgamation, which can be looked at, and then we can consider whether we should go ahead with a demerger or a amalgamation structure, because that may result in a tax neutrality where you don't end up paying any taxes because of the kind of restructuring that you are trying to do. Parul, anything else that you want to take out?
Yeah, I think there is one question with respect to an AIF, and whether if the AIF is going to invest in the overseas entity, whether that will be regarded as round tripping and whether that is permitted, and whether that needs an approval. So there is a specific rule for AIFs whereby AIFs are allowed to invest in an overseas entity. And the requirement as such by SEBI is that the AIF should have a back office in India. And the investment should also conform to the ODI regulations of the RBI. Now, this leads to a kind of a circular kind of an interpretation, because at one side, the FEMA regulations talk about how an ODI cannot be made into an Indian entity indirectly, so they cannot be a round tripping. Whereas the SEBI regulations require specifically that if an AIF is investing into a foreign entity, then the foreign entity needs to have a back office in India. Now, we've had some discussions with the regulators on this aspect, and the way that SEBI has been looking at this issue is that an AIF is permitted to invest into an overseas entity, and they will give an approval for the investment, provided that there is some sort of service relationship with the Indian entity. Indian entity could also be a subsidiary in India, but they are not really looking at a funding which is happening through a round tripping mode back into India. And the funding of the Indian entity has to be from a revenue perspective, and that's what is an indication which RBI has also given to them. So I think that is one question on the AIF.
I think I'll Parul, while you're looking at it and we have 4 minutes left, there's another question on what are the consequences if RBI sees or notices that there is a round tripping issue. To answer that and how we have seen some of our some of the cases which have come to us for advice is that whenever these structures are perceived or taken as round tripping by the regulator, the RBI has actually sent notices for unwinding the whole structure, and getting it back to ground zero. So that's exactly why we go back to the entire essence of this session, which is that you have to be very careful in terms of studying and analyzing different aspects of flipping before you decide on what structure, and then you go ahead and implement it whenever, as and when you are completely decided that you want to go offshore. I think for paucity of time, we will pause the session. We'll stop the session here, and we'll take up other questions which have which have come offline or separately maybe. Over to you, Khalid. And I think just a quick liner on the next next Thursday's session. So we are having another session next Thursday where we will be discussing how to get ready for Series A funding, due diligence issues that are encountered usually in by the investors, and remedies to solve for them.